Welcome to another exciting episode of Legal Aspects of the Education System. We will be discussing student records and confidentiality.
Mr. Law, you sound like a game show host. Is that intentional?
Miss Statute, I thought I would try to liven things up a bit. As you are aware, this episode features a rather dry topic.
If you insist. What is next, a live studio audience?
I was just about to get to that.
Are you finished?
Quite. On with the lesson then. The area of student records and confidentiality is broad and filled with much litigation. As you can see here, we will be discussing two federal statutes. Guidance will also be provided for avoiding legal pitfalls.
The Family Educational and Privacy Act of 1974 is also referred to as the Buckley Amendment. It is a federal law designed to protect the privacy of students' educational records. The law applies to all educational agencies that receive funds under an applicable program of the U.S. Department of Education. Similar to other federal education statutes, a violation of this law can result in a loss of federal funds for the school.
FERPA gives parents significant rights with regard to student records that are not easily terminated, unless prohibited by court order. A non-custodial parent should be afforded the same right to access student records as the custodial parent. You must have something specific in writing from a court or judge to limit access. FERPA does not distinguish between separated parents. Both have equal rights under this law.
Two notes regarding parent and student rights. 1. An eligible student is defined as a student 18 years or older, or an emancipated minor. And 2. Parents may challenge the content of student records and ask they be amended. If a school declines the request, they have the right to a hearing. Schools must always have written parental consent to release student records. However, there are instances when records may be released without consent. Here is a list of such exceptions. Note: to release the records of students in legal difficulty for behavior outside of school, written parental consent is required.
Educators can view records if they have a legitimate educational interest. That is, a record review that is necessary for a school employee to perform their specified job duties. Let's look at an example to clarify this.
Excuse me, Mr. Principal, I have a request.
Yes, Mrs. Apple. Good to see you this morning. What can I do for you?
Well, I noticed that next year, I am going to have Johnny Doe and Freddie Smith in my class.
Yes. Go on.
Well, I understand they are real jerks. I heard in the teacher's lounge today that they got into a fight at recess. I would like to review all of their discipline records to see what I can expect from these two next year.
Hold it right there. At face value, this may sound like a legitimate request. Upon closer inspection, this information is really not needed for Mrs. Apple to perform her specific job duties. Mrs. Apple is currently not the teacher of these students. Also, this occurred at recess, not in an instructional setting. Finally, discipline records are usually considered temporary. Certainly not something to be reviewed in subsequent school years unless a pattern becomes evident.
I knew that.
Right.
A good general rule of thumb is this. If it sounds like prying, it probably is not a legitimate educational interest. In addition, staff should be careful with personal notes about students. If they are shared with anyone, they become an educational record. Also, a written log of all student record reviews conducted by school employees must be maintained.
Finally, directory information is a unique exception to the general confidentiality guaranteed by FERPA. Schools should annually give parents public notice of what it considers directory information. Examples would include such things as student names, organization memberships, and yearbook listings. Further, parents must be afforded reasonable time to request that such information not be disclosed without prior consent.
There are a few special considerations for discipline records. In 1994, the law was amended to allow school administrators to maintain and share discipline records of students that pose a significant behavior risk. However, A high level of caution must be exercised when handling discipline records, to avoid liability caused by defamation. Defamation can occur if personal or sensitive information is shared with an unauthorized person. If this action results in injury to the student's school standing or diminishes their respect and self-esteem, charges or court action may result.
Slander is one of two common types of defamation that can result in civil liability lawsuits against educators. Gossip involving unauthorized third parties can be a source of litigation. Let's look at an example.
Mrs. Apple, I want to talk to you about some trouble that my daughter Joanne is having.
Yes. Please tell me about your concern.
Well, Johnny Doe has been calling Joanne a fat slut on the playground.
I am sorry to hear that. Though it does not surprise me.
Really? Why is that?
That kid is a real problem. Last week, I heard that he beat up Freddie Smith because they got into an argument over skateboarding. Johnny's parents are not very cooperative either. From what I hear, Mrs. Doe really gave the principal a hard time.
Oh my. I hope something is done about him. He sounds like a troublemaker. Thanks for coming to our PTO meeting, everyone. Are there any questions before we get started with the agenda?
Has anyone's kid complained about a student named Johnny Doe?
Actually, yes. Johnny has been picking on my daughter, Joanne. I spoke to Mrs. Apple about it.
And what did she say?
Well, you wouldn't believe what Mrs. Apple has to say about Johnny. He is beating kids up and causing big problems at that school.
I think we need to talk to those teachers about this. Something needs to be done.
I agree. The school trip is coming up. I don't think Johnny should be allowed to attend. He will probably just, beat up more kids or something.
Beth, I think you need to meet with the principal and tell him that we do not want Johnny going on the trip. He is just too dangerous.
Thanks for agreeing to meet with me, Mr. Principal.
Of course. I always have time for the PTO president. What can I do for you?
Well, the parents of the PTO are very concerned about the dangerous behavior of Johnny Doe. We do not feel that he should be allowed to attend the class trip.
This has gone quite far enough. As you can see, it has become a precarious situation. This teacher's seemingly innocent gossip with a parent has diminished this student's reputation, and may hurt his standing in school. The teacher could be headed to civil court for defamation of Johnny, due to slander if the parent becomes aware of her comments. The principal will need to be careful in resolving this situation in the best interest of the student. Finally, if he is made aware of the teacher's comments, failure to address it may place him in legal jeopardy as well.
Libel is a second common type of defamation. Damaging information should not be placed into a student's record for which there is no factual basis. In particular, discipline record entries can be a source of libel. Educators should refrain from statements based upon opinions such as those involving questions of morality, family and marital conditions, and mental or emotional issues. Here is an example of potential libel on a discipline referral. Beyond the first sentence, there is a substantial amount of subjective information written here. If this unsubstantiated point of view manifests itself in the school, and Johnny's standing as a student is tarnished, libel has occurred. If staff members have concerns such as those on this referral, they should be brought directly to the attention of the principal or counselor. A formal evaluation may be needed. Discipline records should recount just the facts, and contain information that can be used to verify the incident if challenged. Remember that they are student records. Therefore, avoid listing other student witnesses by name.
As an administrator, you may be asked for permission to conduct research in your school. It is important to be aware of the Hatch Act and comply with its mandates for all research conducted in schools. In most cases, this means obtaining written parental consent to include students in research studies. The Hatch Act was amended in 2003. This is known as the Protection of Pupils' Rights Amendment. It prohibits research that reveals information about students regarding the topics listed here, without prior written parental consent. Recently, the Third Federal District Court clarified that these topics can be surveyed if students are kept anonymous and participation is voluntary. In these instances, parents must still be informed of the survey content prior to its administration. Well, Miss Statute, I believe that about does it for another exciting episode of Legal Aspects of the Education System.
I don't know about exciting, but we have certainly overstayed our welcome.
Quite right. Until next time, I am Mr. Law.
And I am Miss Statute, bidding you happy studies.